All right, the court will hear now RBAM Inc. Versus MASCOLO. Is that how you pronounce your client's name, Mr. Watson?
Yes, sir.
All right. I don't know if you were in the room when I announced this, but I got 5 minutes for rebuttal on the clock. You want something different than that?
5 minutes is fine, Your Honor.
All right, sir.
My name is Joe T. Caruso. I represent the appellates in this case. This case really started with regard to the settlement question following a pretrial conference on April 21st, attended by the attorneys and their clients. And Mr. MASCOLO made an offer of $20,000 payable in 3 days. Mr. DeHarish was insistent he wanted to go to trial, but at the recommendation of his client, he made a counteroffer of $25,000 payable in 3 days. The parties walked away. The next day, Mr. Watson sends a letter to Mr. Azar agreeing to the $25,000 and attaching a settlement agreement. And the settlement agreement provided for the payment of the $25,000. It provided that it would be paid 10 days from the date of the agreement, which was the 22nd, not from the execution of the agreement, because it was from the execution of the agreement, and it was provided for in the agreement to be executed by the parties and their attorneys. Nothing was ever signed. So if the time for payment was 10 days for the execution of the agreement, there was no agreement. So if we focus in then of what, other than agreeing to the amount of $25,000, there were several things, several essential terms of the agreement that were not provided for.
Well, even if you don't have an agreement then, did you have an agreement when Mr. Azar sent a letter back confirming you pay $25,000 up, confirming settlement, and that you pay the $25,000, I'll hold an escrow, and then I'll file a notice of voluntary dismissal with prejudice. Do you have an agreement at that time?
Well, at that time, they had an agreement as to those terms, but the things that they still did not have an agreement on was there a requirement for there to be a written agreement? Whose obligation was it to get the $5,000 from the broker?
Well, Mr. Azar's letter, he said it was Mr. Watson's obligation.
Correct. So he made a amendment to the original April 22nd agreement.
Right. So if we don't have an agreement on April 22nd, do we have an agreement when Mr. Watson doesn't object to or accepts the April 30 letter from Mr. Azar? Well, if Mr. Azar says $25,000, notice of dismissal with prejudice, you get the money from the broker. If Mr. Watson says, okay, do you have an agreement at that time?
Your Honor, I think that you have an agreement at that time if there is an agreement on an essential term of any contract, the time of payment. So at that point, if we're assuming that the time of payment is going to be 10 days from the date of the agreement, April 22nd, which would be May 2nd.
But that was rejected. That was in Mr. Watson's April 22nd letter. That's rejected. So let's start with Mr. Azar's April 30 letter and an acceptance of it. And if they don't say the time, what is the time?
Well, first of all, I think the time for payment...
Is there no agreement, or does the law imply a right into that agreement?
I don't think they had an agreement. I think the payment of when payment was due was an essential term of the contract. And if they didn't have a meeting of the minds, and of course Mr. Watson argues that they had a meeting of the minds on the 30th when he got Mr. Azar's letter, because the only thing that Mr. Azar's letter changed was who had to get the money from the broker.
So is your position that if parties agree, have some agreement, and there's a payment going from one party to the other, and they don't say when that payment's to be made, that there's no agreement?
I would say they have an agreement on to the amount to be paid, but an essential element is when it's to be paid. I mean, would the party who's supposed to pay the money then be able to take the position that I don't have to pay you for a year from now because, we don't have any agreement on time?
Well, does the law write into that agreement that it's to be paid in a reasonable time?
I don't believe it does under these circumstances.
Okay.
Especially when the parties in their negotiations were talking about 3 days, and then there's a written agreement that makes it 10 days, and of course Mr. Watson takes the position that 10 days starts from the 30th of April. So that would make it May 10th. On May 10th, nothing had been paid by anybody. And it was 5 days later that Mr. DeHarish says, wait a minute, we haven't been paid within the 10 days they were supposed to pay us. There is no deal. And on the 15th, when he notified Mr. Azar and said, tell them there is no deal, at that point, no money had been received from the broker, no money had been received from Mr. Mazzolo.
Didn't your clients, through their testimony, agree that at least as of the 30th, April 30th or before, that they had agreed to the settlement that was proposed?
They had agreed to the amount of settlement of $25,000.
And at that time, that agreement did not include a time period for the payment, did it?
I think it included the agreement for time payment because Mr. Watson's April 27 agreement said 10 days. Nobody amended that time.
I'm not talking about the proposed written agreement. Your clients testified, I think, at trial that they had agreed to the settlement agreement as orally proposed and agreed to by both attorneys. And that didn't include a time provision, did it?
The only time provision was... Yes.
It also did...
The answer is yes.
It did?
No. I'm sorry. I thought I was... The answer to your question is it did not include a time agreement. The only time was in the written agreement.
And it also, the oral agreement that they testified to, that they agreed to, also didn't include a requirement that the settlement agreement be reduced to writing either, did it?
That's correct. The only suggestion that it was required to be in writing was the proposed agreement itself.
And the trial judge found, I think, in the order that the only reason that the time provision became a factor was your clients wanted to use that as a basis to relieve themselves of the settlement agreement.
No, I don't agree with that, Your Honor. My client instructed Mr. Azar on the 15th, when no money had been received, that the deal was off. At that point, Mr. Azar contacted Mr. Watson and said, look, I'll try to put this deal back together. I think I convinced my client if you can get the money to me by the 22nd. He had no authority to do that. Mr. and Mrs. DeHarish did not tell him that. They told him to tell Mr. Watson the deal was off. So he had no authority to extend the time for payment or no authority to do anything after the 15th of May except tell Mr. Watson that his clients felt the deal was not complied with and there was no deal.
Mr. Crystal, just so I understand your argument, your argument is first that there was no agreement as to the date of payment. And alternatively, if there was, it would have been the 3 days or the 10 days, and they didn't comply with it. Would that be a fair summary of your argument?
I don't think that the 3-day agreement was ever agreed to, Your Honor, because that was the negotiation following the pre-trial conference. I think that the 10 days that was in the agreement that nobody ever changed is what, obviously it was agreeable to Mr. Mazzolo because he had his attorney put it in the agreement. It was agreeable to Mr. and Mrs. DeHarish because they didn't tell Mr. Azar to set a different time rate. So I think that the 10 days was the date that everybody contemplated would be the day of payment.
All right. So is your position that there was an agreement and that agreement provided for payment within 10 days?
10 days from
as opposed
my position, April 22nd.
There was no agreement because there was no agreement as to time of payment.
I think that if there was no agreement for the time of payment, then there was no agreement. But if there was an agreement for the time of payment, it was 10 days from the 22nd. That's my position, which would have made it May 2nd. And it's Mr. Watson's position, it was 10 days from the date that Mr. Azar sent the letter on the 30th, which would have made it on May 10th. In any event, there was no payment by either date, regardless of which date is correct. So it's my client's position that on the 15th, he had every right to instruct his attorney because the payment that was an essential element under the contract or agreement had not been complied with, and instructed Mr. Azar
The trial court found that the time requirement was not an essential part of any agreement. Here's what the trial court found. The time frame of 10 days was recited by the written agreement dated April 22nd, 2009, and a reasonable time for performance was contemplated by the parties at in their various subsequent communications, but time was not explicitly made of the essence.
I respectfully disagree.
And the reason, I think, for that is that April 30th or before, your clients even testified that they had accepted the settlement agreement. The settlement agreement provided for no time frame for payment. And that's exactly what the trial court found. So aren't we supposed to take a look and see if the findings are supported by substantial competent evidence? That's it? You lose?
I respectfully disagree with the trial court's findings for this reason. The trial court said that the parties contemplated a reasonable time. There is no time ever mentioned anywhere except in the draft of the settlement agreement, which is 10 days. And no correspondence after the 22nd of April, and any correspondence from Mr. Watson to Mr. Azar, from Mr. Azar to Mr. Watson, or anything that suggests that it would be other than 10 days.
Well, here's the further finding by the trial court. The only instance in which time for performance was raised was when plaintiff's former counsel, Mr. Azar, advised Mr. Watson on or about May 19th that performance must happen soon, quote, soon, or, quote, by Friday, May 22nd, 2009, or settlement might not happen, end quote, and the settlement might be rejected by plaintiffs. The term soon was not defined by Mr. Watson, Mr. Watson did tender all funds by May 22nd in performance of the agreement. Those are specific findings, and you're saying that those are all not supported by competent substantial evidence in the record?
Everything you have just said happened, except it all happened after May 15th, when Mr. Azar had no authority to extend the time. At that point, he had been told by his clients that they had not received payment within the 10 days, and the deal was off. He had no authority. I recognize what he did. He had no authority to do that, and he can't bind the client to it.
Let me ask you this. If the contract was breached for failure to pay in a timely manner, why do you get to rescind it? Why isn't that just a classic run-of-the-mill failure to pay, and your damages are measured by the amount of the contract?
I wasn't trial counsel below, Your Honor. I really can't. I really can't say.
I mean, but if what you say is correct, I think it's your alternative position. Your position number one is that there was no meeting of the minds on the essential elements and there was no contract.
Correct.
Your alternative position is even if there was, they breached it by not paying it on time.
Correct.
My question is directed to your alternative argument, and my question is, isn't it just really kind of fundamental contract law that if you breach a contract by failing to make payment, that the remedy is that you get a judgment for that payment for those damages? Why would you get to rescind it and go back to square one?
Well, if the contract had not been complied with, I think that you have, if the other party, in this case, the payor, doesn't pay under the contract, I think the buyer's got two remedies. The buyer can rescind the contract, right, or the buyer can adopt the contract and sue for performance.
But isn't rescission an equitable remedy, and doesn't the trial judge have some discretion whether or not to grant rescission or to just allow you to have the damages?
That issue never came up, Your Honor. It never came up because it never got to that posture. Once the court determined that there was a settlement agreement and enforced the agreement and required the filing of a notice of dismissal with prejudice, it was the end of the case except for the appellate remedy.
I know it wasn't argued. I'm just, sometimes we delve into these tipsy coachman issues, and That's what I'm trying to say.
Let me ask you this. The trial court also made this specific finding, and it says, just as arguably, the period of time for full performance was from April 30th, 2009 to May 22nd, 2009, a period of approximately 22 days. The court finds this to be a reasonable time for performance. So if we assume, and just bear with me for just a minute and make my assumption, if we assume that they did not agree that time was of the essence, then a reasonable time period would be inserted by the provisions of the case law. You don't dispute that would be a reasonable time period for performance, do you? As found by the trial court?
On the question of reasonable time for performance, I'm not saying that that's not a reasonable time for performance.
Okay.
What I'm saying is I don't think the trial court, when there is no other time in any correspondence, any communication, anything other than the 10 days, what the trial court is doing in this case and could in every case is rewrite the contract between the parties and say, okay, I'm going to find that a reasonable time is X, Y, or Z.
Well, my question to you is you don't dispute that if we find that time was not of the essence and that was part of the agreement, that would be a reasonable time for payment.
I do.
You do? You dispute that?
No, I do not dispute it. I was agreeing with you. I agree with you.
I'll say some rebuttal time.
Thank you, Your Honor.
All right, got a little over 4 minutes, sir.
Morning, my name is Victor Watson. I'm here representing the appellee, James MASCOLO. Basically, this is just a case of settlor's remorse. The court should keep in mind there were 3 evidentiary hearings on this matter, just strictly with regard to the motion to...
Let me ask you this. Ordinarily when you prepare a contract in writing, you take the time to do that and you tender it and it contemplates that the parties are all going to sign it. Ordinarily, the contract doesn't become a binding contract until everybody signs it. How'd you get around that in this case?
Your Honor, that was in this case was a mere formality. There was no statute of frauds issue. This is something that could be all completed within 22 days.
I remember your testimony that it was a mere formality, but it was in the formation of a contract, whether it's a statute of frauds case or not. As I recall, the law, the parties can contemplate a written document, and if they contemplate a written document, an integrated written document they're not going to be bound by until everybody signs it, if that's the intent, then no contract is formed until it's signed, right? Whether it was a mere formality or not.
No, Your Honor, there can be an oral agreement reached. Remember that. As Mr. Caruso described it, there was a pretrial conference. We discussed settlement at that time, discussed terms. My client refused the offer of $20,000 or $25,000. He offered $20,000, which included the $5,000 deposit. So he had to provide an additional $15,000, and the other side had to go back to its realtor and get approval of the $5,000 release, and my client had to go to the selling agent, get its approval. That offer, my client came back and said, well, okay, let's go ahead and settle at $25,000. I sent the short agreement, and basically this was all based on the discussions. The agreement that was sent really didn't have anything more than what was discussed. I was somewhat confused at that point because I thought the offer was still on the table. Mr. Azar was very clear to me when he received that. He called back and he said, look, the offer that we made was good for the day when we were there at the pretrial. It's not there anymore. That offer is not outstanding. But I will take this to my clients. So he took it to his clients, and the testimony was they discussed it. Mrs. DeHarsh really wanted to settle. Mr. DeHarsh didn't want to settle. Mrs. DeHarsh was the one calling the shots at that point. And 8 days later, Mr. Azar sends to me the letter saying this confirms the settlement at $25,000. And there were communications between us. And he sent a letter in writing confirming.
Did Did Mr. Azar have authority to do that?
Yes,
Or
he
Mr.
did,
Lyon?
and there was testimony at all of the hearings that he did have authority to settle for them, and to enter this settlement agreement at $25,000. It was very clear. It was asked a number of times, and they agreed that he had that authority. He had authority through May 15th.
Although a written contract wasn't required here, does the provision of 10 days suggest, or arguably suggest, that you thought, or your client thought 10 days was the reasonable time to pay?
Well, recall that when that was submitted, it was 10 days. All my client had to do was to provide $15,000. It was up to the other side to go back to the realtors and get the additional $5,000. And those realtors, arguably both of them, were the agents of the seller. Clearly the listing agent was the agent of the seller. The selling agent, who had been dealing with my client and who did hold the deposit, had a closer relationship with my client. We already knew that he would agree to this. He had already told us this. It was the listing agent that was working with the DeHarshes that had to be dealt with.
So it's your position that when Mr. Azar sent the letter on April 30th, putting the burden on your client to get the realtor to release the money, that changed?
We had to now go get another $5,000. We had to deal with the person he was dealing with. We had to provide an additional $5,000 as well, and it was 8 days later. So we had to get another $10,000. So although 10 days might have been reasonable to provide what we had at that point, we might have needed a little more time to go get additional funds. So I don't think 10 days was unreasonable. The court specifically looked into this issue and found that 22 days was not unreasonable. I don't think that was unreasonable. I think that under the circumstances, since the amount of money changed, since the burden shifted as to who was to obtain these funds, that the reasonable time which was imputed into the contract, and clearly under Florida laws, a reasonable time is implied if the matter is not addressed, then that was, 22 days was a reasonable time as found by the trial court after all the evidentiary hearings. Now, I relied heavily on the case of Patrick versus Christian Radio, because that's a 5th DCA case. It incorporates all of the settlement agreement cases and so forth. It states that a settlement agreement can be sufficiently specific and mutually agreeable as to every essential evidence, even though there were certain documents that were not signed. And importantly, the court quoted the case of Smiley versus Greyhound Lines, another 5th DCA case, to state that when there's a full evidentiary hearing, before determining that there was a settlement, the findings of the trial court come to this court clothed with a presumption of correctness. And where there is substantial competent evidence to sustain the actions of the trial court, the appellate court cannot substitute its opinion on the evidence, but must rather indulge every fact and inference in support of the trial court's judgment. Trial court has the first-hand opportunity to observe the witnesses and so forth. We had 3 evidentiary hearings on this matter. Whether you look at the first evidentiary hearing, which was the hearing on the motion to enforce, or you look at the second one, which was really a hearing on whether or not the DeHarshes were now entitled to come back and re-argue it based, with new independent counsel, or you look at the third evidentiary hearing, where they now had independent counsel who came in. Their prior attorney was forced to come in and now testify on their behalf. He had testified earlier, but now he was being cross-examined by the DeHarshes' new attorney. At that hearing, everyone agreed there was an agreement. They all testified that an agreement had been reached, and numerous times. An agreement had been reached on or about April 30th. Mr. DeHarsh was asked, did your attorney, David William Azar, have authority on your behalf to settle this matter for you? Answer, yes. He was asked, so the reason you're upset with the settlement you reached was because you had not received the money by May 15th. Is that correct? The answer was yes. Mr. DeHarsh was asked by Mr. Caruso, so as I understand your testimony, Mr. Azar had initial authority to settle the case on you and your wife's behalf for $25,000 on certain conditions. Is that right? The answer was yes. He admitted that it was not part of the settlement agreement that payment had to be made in 3 days. Again, if the time is not stated, the law implies a reasonable time. The testimony goes on and on numerous times when they just admitted that there was an agreement. An agreement had been reached. Clearly, as your questions indicated, if the payment had not been received, within the time that they thought was reasonable, that would have been a breach of the agreement. They could have filed an action to enforce the agreement themselves or filed for a breach of contract. They would have been entitled, I guess, to statutory interest. I don't know what that would have been, $200 maybe. Certainly a lot less time than we've spent, arguing this. So I think everything shows that there was an agreement reached. All of the essential terms were reached. Mr. Caruso tries to argue that time was of the essence. First he tries to argue that there was no authority to settle the case. The testimony was that there was authority to settle the case. Then he argues that the essential terms were not agreed upon. However, it's admitted throughout the testimony that there was an agreement reached, that the essential terms were the payment of the $25,000 and the dismissal of the case with prejudice. Mr. Caruso's next argument is that time was of the essence. The case law has the 4 requirements for when time is of the essence. It was certainly not stated anywhere in any of the documents or letters or anything else or in the verbal agreement that time was of the essence. There was nothing about the case that would make it, the situation that would make time of the essence. The only factor that might have eventually made time of the essence was when Mr. Azar notified me that you better get the money here in a couple days, or they may withdraw from the settlement. And that's how it was characterized as well through the testimony. For the most part, it was considered a withdrawal from the settlement or termination of the settlement agreement. It wasn't a withdrawal of the offer to settle. So it was very clear that an agreement was made. Mr. Mascolo complied with the terms of the agreement within a reasonable time. He, if anything, there arguably could have been a breach of the agreement for not providing the money within time. But as you questioned, that would not cause the agreement to be rescinded in any way. It would simply be, give them some kind of an action for damages. So an agreement was reached. This was all heard by the trial court. Full evidentiary hearings. The court's decision, the court looked at all of these issues, made specific findings of fact as to all of the issues, and determined that a settlement agreement had been reached and enforced the settlement agreement, and the judge acted properly.
All right, sir. Thank you.
Mr. Watson talks about the Patrick case. The Patrick case was one of your cases out of this 5th district. It's markedly different from our circumstance. In the Patrick case, the plaintiff had testified that he had given him settlement authority and that all of the essential elements of the agreement had been agreed to. The court found that his testimony, along with the attorney's concession that all the essential elements of the agreement had been agreed to, constituted competent substantial evidence to support a determination that the settlement should be enforced. Markedly different from this case. And with regard to if you look in the record, and it's recited in my brief, Mr. Watson conceded at the last hearing that his client had agreed to pay within 10 days. And he disagreed with 10 days from April 22nd, but he said the 10 days ran from April 30th. He agreed that payment was due by the 10th. If parties agree that money is due by a certain date, I suggest to the court that that is the date that time is of the essence for. You don't need to add the words time is of the essence after you reach the agreement for the date. So I suggest that the agreement was breached by Mr. MASCOLO, and that the trial court's decision with regard to inferring that there was no agreement as to time is incorrect and should be reversed.
All right, thank you, sir. Thank you both for a well-argued case, and the court will be adjourned at this